Right as a noun and taken in an abstract sense. The term means justice, ethical correctness, or consonance with the rules of law or the principles of morals. In this signification, it answers to one meaning of the Latin, jus, and serves to indicate law in the abstract considered as the foundation of all rights or the complex of underlying moral principles which impart the character of justice to all positive law or give it an ethical content as a noun and taken in a concrete sense. A right signifies a power, privilege, faculty, or demand inherent in one person and incident upon another. Rights are defined generally as powers of free action, and the primal rights pertaining to men are undoubtedly enjoyed by human beings purely as such, being grounded in personality and existing antecedently to their recognition by positive law, but leaving the abstract moral sphere and giving to the term a juristic content. A right is well defined as a capacity residing in one man of controlling, with the assent and assistance of the state, the action of others. The noun substantive, a right, signifies that which juris denominate a faculty, that which resides in a determinate person by virtue of a given law, by which avails against a person or answers to a duty lying on a person, other than the person in whom it resides. In that noun, substantive rights is the plural of the noun substantive a right. But the expression right, when it is used as an adjective, is equivalent to the adjective just, as the adverb rightly is equivalent to the adverb justly. And when used as the abstract name corresponding to the adjective right, the noun substantive right is synonymous with the noun substantive justice. In a narrower signification, the word denotes an interest or title in an object of property, a just and legal claim to hold, use, or enjoy it, or to convey or donate it, as he may please. The term right in civil society is defined to mean that which a man is entitled to have, or to do, or to receive from others within the limits prescribed by law. That which one person ought to have or receive from another, it being withheld from him or not in his possession. In this sense, right has the force of claim and is properly expressed by the Latin jus. Lord Coke considers this to be the proper signification of the word, especially in writs and pleadings, where an estate is turned to a right, as by discontinuance, dissation. Classification. Rights may be described as perfect or imperfect, according as their action or scope is clear, settled, and determinate, or is vague and unfixed. Rights are either in personam or in rem. A right in personam is one which imposes an obligation on a definite person. A right in rem is one which imposes an obligation on persons generally, either on all the world or on all the world except certain determinate persons. Thus, if I am entitled to exclude all persons from a given piece of land, I have a right in rem in respect of that land. And if there are one or more persons, A, B, and C, whom I am not entitled to exclude from it, my right is still a right in rem suite. Rights may also be described as either primary or secondary. Primary rights are those which can be created without reference to rights already existing. Secondary rights can only arise for the purpose of protecting or enforcing primary rights. They are either preventative or remedial. Sweet. So they are either preventative, protective, or remedial, reparative. Preventive or protection secondary rights exist in order to prevent the infringement or loss of primary rights. They are judicial when they require assistance of a court of law for their enforcement, and extrajudicial when they are capable of being exercised by the party himself. Remedial or reparative secondary rights are also either judicial or extrajudicial. They may further be divided into rights of restitution or restoration, which entitle the person injured to be replaced in his original position; rights of enforcement, which entitle the person injured to the performance of an act by the person bound; and rights of satisfaction or compensation. With respect to the ownership of external objects of property, rights may be classed as absolute and qualified. An absolute right gives the person in which it inheres the uncontrolled dominion over the object at all times and for all purposes. A, qual- a qualified, or let's see, qualitative right gives the possessor a right to the object for certain purposes or under certain circumstances only. Such is the right of a bailee to recover the article bailed when it has been unlawfully taken from him by a stranger. Rights are also either legal or equitable. Look at all that I gotta read. The former is the case where the person seeking to enforce the right for his own benefit has the legal title and a remedy in law. The latter are such as enforceable only in equity, as at the suit of cesti que trust. There is also a classification of rights with respect to the constitution of civil society. Thus, according to Blackstone, the rights of persons considered in their natural capacity are of two sorts: absolute and relative. Absolute, which are such as appertain and belong to particular men merely as individuals or single persons; relative, which are incident to them as members of society, in standing in various relations to each other. Rights are also classed as natural, civil, and political. We mean by natural rights those which by fair deduction from the present physical, moral, social, and religious characteristics of man he must be invested with, and which he ought to have realized for him in a jural society in order to fulfill the ends to which his nature calls him. Political rights consist in the power to participate directly or indirectly in the establishment or administration of government. Civil rights are such as belong to every citizen of the state or country, or in a wider sense, to all its inhabitants, and are not connected with the organization or administration of government. These rights are such as belong to the juristic personality of the individual or pertain to him as a member of the community. They include the right of freedom of property, of marriage, of protection by the laws, etc. As an adjective, the term right means just, morally correct, consonant with ethical principles or rules of positive law. It is the opposite of wrong, unjust, illegal. Right is used in law as well as in ethics as opposed to wrong. Thus, a person may acquire a title by wrong. In Old English law, the term denoted an accusation or charge of crime.